All right. This is State of Michigan versus Terrence Jordan, case 2205839501, and State of Michigan versus Dekaya Straughter, case 22058395503. Today is the date set for a preliminary exam held in Park. Appearances, please.
Good afternoon, Your Honor. Natea Scott on behalf of the people, P78816.
Good afternoon, Your Honor. David Cripps, P34972, appearing on behalf of Terrence Michael Jordan Jr., who's here in court. Tell the judge your name, please.
Good afternoon, Your Honor. Terrence Michael Jordan Jr.
Good afternoon, sir.
Good afternoon, Your Honor. Good afternoon to your staff, Neighborhood Defender Services by Ken Riggins, P82125 on behalf of Mr. Dekaya Straughter. Straughter, please state your name for the record.
No, Dekaya Straughter.
Good afternoon, sir. All right, today is the date set for the continued exam. Before we get started, are there any preliminary matters or motions that we need to discuss?
Yeah, my apologies, go ahead. Yeah, I spoke with my client regarding holding the rest of the preliminary examination. My client, based off certain statements that were made previously in testimony, my client does not feel it necessary to hold the preliminary examination. My client respectfully actually waived the preliminary examination.
Ms. Scott?
I object. The people are entitled to a preliminary examination. It's already in progress, Your Honor. It's actually fruitless to waive at this point. The testimony then we exhausted the court's time, the witness's time. The people object.
Maybe not fruitless to you, but that being said, we're going to go forward with the exam.
Your Honor, it's the people's understanding. I sent an email to the court as well as the defense counsel asking whether or not the last transcript, which includes Dunning's testimony, Sergeant Dunning's testimony, was received. It's my understanding that neither defense counsel nor I have received it. It has also come to my understanding that not only is Dunning's testimony in that particular transcript, the subsequent OIC is testimony in that transcript, which is Sergeant Alexis Kim. So we don't have those records, Your Honor.
Mr. Riggins, you were here for Sergeant Dunning's retestimony as well as Investigators Campbell. Are you comfortable going forward today, based on knowing that we don't have those transcripts yet?
As I recall, the testimony dealt with Defendant Jordan. It did not deal with Defendant Straughter, so I don't know if it would be appropriate for me to answer that because it didn't deal with my client.
Everybody.
Of course. So to the extent that it did not deal with my client, yes.
Mr. Cripps. And I will note that the request for the transcripts happened before Sergeant Dunning retestified as well as Investigator Campbell. That being said, it's a request for trying to get all of the transcripts together. So I don't think anybody is out of sorts for not having that testimony. We adjourned this for a while to get Mr. Riggins caught up. But if we need to, I'll consider it. But I think we should be fine going forward.
Well, that was my argument at the last hearing, Your Honor, that we could go forward because Attorney Riggins was present and able to cross-examine the witnesses. The only thing was, Your Honor, as to his clients, the court would not allow me to ask Sergeant Dunning questions regarding his client because the court wanted all of the transcripts in their entirety. So any questioning that I was going to ask Sergeant Dunning regarding Mr. Straughter, I could not ask him.
But you can ask him now.
He's not here.
Did you intend to call him?
I can get that testimony, the testimony I need out of him, I can get out of Alexis.
Did you intend to recall her?
Yes,
Well done.
I'm just making.
Yeah, so, Mr. Cripps?
Judge, I would object to any further testimony. She's testified already. We're prepared to argue in opposition if I don't already know.
Do you have other testimony as far as Investigator Campbell as it relates to Mr. Cripps' client
I do,
that we didn't do the first time?
correct. Well, the court stopped Sergeant Dunning's testimony. I don't know if the court accepted his answer. I asked the sergeant whether or not the defendant had a valid concealed pistol license, and the court stopped his answer because the court stated that I couldn't ask any questions
as to Mr. Strader?
So I asked as to both. My question was twofold. I asked as to both, and the court said, no, we're not gonna take any further testimony about that.
And, Your Honor, if it facilitate matters, I spoke with my client about this. At the time of this incident, my client was 17 years old. The law does not allow you to have a CPL until the age of 21. So we will stipulate that at the time of this event, for example, only that Mr. Strader did not have a valid CPL.
Well, I'm gonna allow the testimony. I think this is this is a point that we can figure out pretty easily. We know,
You're long.
I'm sorry. Go ahead.
No, wait till you finish.
No, I'm saying, Investigator Campbell was testifying. She's here today. We just finished the testimony.
But I can't use any impeachment from the last transcript. If there's going to be any proofs offered against Mr. Jordan. I don't understand.
I mean,
She's already testified once already.
I don't understand why we're getting this testimony as to a CCW. But, you know, here we are.
Because I need to establish the elements of CCW, which is that fact, which includes the defendant not having a valid concealed pistol license, because if he had a valid concealed pistol license, then he would not be carrying a concealed weapon.
I heard testimony of where those weapons were found, and, you know, I think we've already met that. But
Very well, Your Honor. All right, the people are prepared for argument.
all right. Are there any more witnesses?
No. And the people will rest, actually.
Okay, are you guys prepared to make arguments? Or, so I'm prepared to hear them, but, you know, I thought we had additional witnesses.
I'll put the last offer of proof on the record that that's what the RT was testifying to, whether or not the defendant had concealed pistol license. Yeah, I may have a 5-minute recess.
Sure. All right, back on the record, matter of Jordan and Strader. Ms. Scott, whenever you're ready to proceed with an argument.
Thank you. Mr. Homer Ellis testified that on December 13, 2021, he was in the area of 6 Mile in Wayne County at approximately 1 or 2 a.m., according to his sworn testimony. He had just left his vehicle to walk his sister, I believe it was, to her vehicle. And that before he approached the sister's vehicle, a white Malibu with a black bumper pulled up, and he stated that they were in a white Malibu and he was robbed at gunpoint. He testified that he was robbed of a gray Charger and his handgun. He said that the handgun was on his hip, and that there were 2 or 3 people with guns, and one guy had a laser pointed at his face, him being the complainant in this matter. He saw 2 guns, we saw 3 people in the Malibu. He said 2 people got out of this Malibu. He also testified that he had a permit to carry this particular gun. And just fast forwarding, Your Honor, well, let me stop. He testified that the individuals were wearing masks. So there's no secret that he couldn't point out who did this. This is a circumstantial case, Your Honor. And the case law, People v. Beck, says that not only does the case law state, but the jury instructions state that circumstantial evidence is just as effective as direct evidence in proving the elements of a crime and proving identity. He said that the individuals said to him, "Give me the keys," at which time he dropped the keys to his vehicle. He said that the 2 individuals then got out and jumped into his vehicle, which was the Charger. He said that one of the individuals took the gun off of his hip. That's directly consistent with what Officer King testified to, who was the OIC at the time. He testified that he took a statement from defendant 3 in this case. And Your Honor, I'd like to approach with People's Exhibit 3, if that's okay.
Sure.
Is that being offered against Mr., that can be offered against Mr. Jordan?
Defendant 3, which I'm assuming is the office, Mr. Starter, is that correct?
Correct.
Yep, only asking Mr. Starter.
Thank you.
I'm going to draw the court's attention to page 1 of the interrogation. The officer asked Mr. Strogler, "Did you take a Dodge Charger last night?" He said yes. He said, "How did you take the Charger?" Answer, "The guy had threw the keys." The officer said, "The victim?" question mark. The defendant says yes. He said, the officer asked him what happened next. He said, "I picked up the keys and drove." The officer asked him, "Where were you at?" He said, "I was on 6 miles." The officer asked him, "Do you have a gun?" The defendant replied, "Yes." Your Honor, Officer Matiba testified that he received information about this particular investigation involving a stolen Charger, and he was dispatched to locations 14202 River Road, Detroit, about 3:30 a.m. He saw the Charger there that was reported stolen. He said he set up surveillance on the vehicle. He said as he was there, he observed a Malibu that was reportedly used in the carjacking pull up. He stated that 3 people got out of that Malibu and got into the Charger. The investigation, as the investigation goes on, Your Honor, the Officer King testified that, I'm sorry, it was Sergeant Dunning. No, it was King, I'm sorry. May I approach People's Exhibit 2, Your Honor?
You can.
What is Exhibit 2? Thank you.
King testified that that was the vehicle that he observed when he also went to the location, and that based on the investigation to that vehicle belonged to Terrence Jordan Sr. Matiba stated that he saw the 3 individuals get out of the Malibu and then get into the Charger, which other testimony revealed later that that was indeed the stolen Charger that the individuals that all the officers were looking for, Your Honor. It was established by King's testimony, it was established by Dunning's testimony. Dunning actually stated that he was listening to Sirius in order to track this particular vehicle. and that's how they ended up at the Riverview Apartments. Matiba stated that once the three people got out of the Malibu, they got into the Charger, and then they followed the Charger to the BP gas station, at which time the officers were ordered to take down the vehicle, the stolen vehicle. Matiba testified that Judge was in the back seat and that there was a black semi-automatic weapon that had fell to the ground. He said that the passenger at that time was Strother, and that Jordan was driving, and he gave the vehicle license plate PLG 9470. The people called Officer Clark. He also testified that he did surveillance while at the Riverview Apartments regarding the carjacked vehicle. And he also corroborated some of Matiba's testimony in that he saw the occupants from the Malibu get into the Charger. And then he followed the Charger to the gas station, and he saw Mr. Strother get out of the back seat. He made an in-court identification as to Mr. Strother, and he said that Mr. Strother had a weapon in his possession, which was a Glock 9. He testified that he retrieved that weapon and he put that weapon onto evidence. And I believe it was Dunning's testimony that stated that King's testimony that he ran a lien onto that Glock 9, and that Glock 9 indeed belonged to the complainant and Mr. Homer Ellis in this matter, which again is consistent with Strother's testimony that he took the weapon from, he said he took the keys from the victim in this matter. And
I don't think Mr. Strother testified. His statement.
Correct. Mr. Strother's statement was that he indeed took the weapon from Mr. Ellis. And Mr. Ellis reported that his gun was also taken, and that gun came back to belonging to him, found on Mr. Strother's person. So we see here that the elements as to carjacking are definitely met as to him, because they're found in a stolen vehicle, which belongs to Mr. Ellis, and Mr. Ellis' weapon is in that vehicle on the person of Mr. Strother. So people believe that the elements as to the person who took that weapon are met as to Mr. Strother, that I proved my elements to a probable cause standard. That on December 13, 2021, Mr. Strother participated in the carjacking, whether he aided and abetted him, but he participated in the carjacking. He took his vehicle, he admitted to taking Mr. Ellis's vehicle, and he took his weapon. Sergeant Dunning testified that he went to the 6 Mile location, and then he received information that that the car was hanging in the Riverview Apartments, and that he also observed the Malibu with the black bumper, and that he's the one that did the he's the one that readily on the victim seat that it belonged to Mr. Terrence Jordan Sr. He identified Jordan as the driver of the vehicle, of the stolen vehicle, because he then went to the gas station, and he's the one that actually ordered the takedown. He said that he identified Jordan, he identified Strother. Jordan was on the driver's side of the stolen vehicle. Strother was on the passenger side. He said that he observed a gun in between Mr. Jordan's legs, which was a 9mm Glock, and that this particular gun had a blue laser. What's important about this laser, Your Honor, is that this is the same characteristic of the gun that Mr. Ellis testified to having in his face when his vehicle was taken, a gun with a laser. And then I asked Sergeant Dunning, I believe I asked Sergeant Dunning, does he have a gun with a laser? And he said no. And we heard from Mr. Jordan's jail calls that he admits to having a gun, he admits to having guns, and he's talking about when the police came to arrest him. He's saying that the police don't have the type of guns that I have. They're not ready for me. And he thought it was one big joke, talking about the police are don't have the type of weapons he has, and he's ready for them. And he's correct, the police are not walking around with guns with lasers on them. So people believe that based on Dunning's testimony and Clark's testimony, that they're both carrying concealed weapons in this stolen Charger that they're found in possession of. Now, Coach Ryan,
Yes.
this is People's Exhibit 7.
What is 7, please?
This is a picture from the jail call.
Yes.
Video, snapshot.
Yes. Sergeant Dunning also testified to recovering an iPhone 11 out of this particular vehicle. He stated that he did a search warrant for this phone, and that when the search warrant, that in his search warrant, he listed the number of 677-2159. Alexis testified that she also subpoenaed subscriber information for this particular telephone number, which was 313-677-2159. The people placed the call detail records onto evidence, Your Honor, which was People's Exhibit 6. The call detail records came with a certification from T-Mobile. That was People's Exhibit 6 and 6A. May I approach, Your Honor?
Yes.
It was People's, the T-Mobile certification was People's Exhibit 1. I apologize. And the phone up was admitted into evidence, but I'm only going to approach with the certification that came with the call detail records.
Thank you.
Right, that document there has the subscriber information, which corresponds to the telephone number of 677-2159, which was from the phone that Sergeant Dunning recovered from the stolen Charger. The subscriber information says Janiyah Jordan. Alexis, Officer Campbell also testified that she also wanted to search the meta records, also known as Instagram, for an individual who she believed to be Mr. Jordan in this case. This is People's Exhibit 6 and 6A. The meta records were over 9,000 pages. The people put those into evidence and also gave those to defense counsel. May I approach with the certification for the meta records?
Can.
What's significant about those records, Your Honor, is that it comes with identifying information. Identifying information in that record has the same telephone number of 677-2159. That telephone number, again, is the telephone number from that cell phone that was recovered in this stolen vehicle on December 13th. Janiyah Jordan was not found in that vehicle on December 13th. Mr. Jordan was. What's also significant about that certification is that there's an email address associated with an individual. That email address is karenmjordan23@gmail.com. That's circumstantial evidence that the person who had that phone was the person, and we know he was in the vehicle because the officers arrested him in that vehicle. Those car detail workers were analyzed by analyst Steve. Now I approach with people's exhibit 5, Your Honor.
You can, 5 is the,
Map.
and,
Yes. If you look at that map, Your Honor, Steve testified that she was given a time for the incident, which was at 2:10 a.m. Again, that's the same time that Homer Ellis testified to him being carjacked around, he said 1 or 2. So around 2:10 a.m., that was the target time that Steve put into this map in order to create a map of the car detail records for this phone 677-2179. If you look at page 3 of that report, Your Honor, clearly at the target time, well, after the target time, which would have been 2:11:05, you see all the car details from 1 to 14 from page 1, and you cross-reference that with page 3, you clearly see that that phone is pinging in the area of 6 Mile at around 2 a.m. That's the same location that Mr. Homer testified that he was carjacked of his vehicle. The issue in this case is whether or not Mr. Jordan carjacked Homer Ellis. Let's just put it out there. And what are the people relying on? Your Honor, we know that when that vehicle pulled in the white Malibu Charger, which Mr. Homer Ellis testified to seeing pull up alongside him before taking his vehicle, we know that Mr. Jordan was in that area. We know that he was in that vehicle. He's then found in that vehicle at the Riverview Apartments. His daddy is not driving that vehicle. Him and 2 other people are in this vehicle. They get out of this vehicle, get into the stolen vehicle, and then we know that all 3 are then arrested because that's the case before this court. The people believe that although circumstantial, this is very, very explicit evidence that Mr. Jordan was in that vehicle and that he was one of the individuals who jumped out with a laser, pointed at Mr. Homer's face, and then took his vehicle. Again, Janiyah Jordan was not in that vehicle. Terrence Sr. was not found in that vehicle. Mr. Jordan and Mr. Strawber and Mr. Judd are the ones who riding around in this Malibu and then took this man's vehicle at gunpoint and then took his gun. The people believe that it has met its burden as to okay. One more, yeah.
sure.
People believe the embedded burden as to both individuals, but specifically with regard to Mr. Jordan, count one carjacking, count two armed robbery, count three CCW, and the associated felony firearm charges that are associated with those counts, Your Honor. Logically speaking, again, Mr. Terrence Jordan Senior was not found in that vehicle. He was not in the area where those cell phone records are pinging on 6 Mile at the time that the carjacking was reported. That gun with the laser that he pointed in that man's face that was found on him served to prove that he was indeed at the location and he indeed participated and gave participation by bringing his dad's vehicle and then driving away a stolen vehicle with the other two people that he was found with. We believe that the burden is met and that my burden is probable cause and that Mr. Jordan indeed aided and abetted Mr. Strother in carjacking and armed robbery of Mr. Homer Ellis on December 13, 2021, I ask you to find over his charge.
Mr. Cripps, whenever you're ready.
Thank you, Your Honor. It's pretty clear in this case that there is absolutely no direct evidence. And that's why Ms. Scott is grasping at all these various different details, none of which I think are really around in the evidence. And what it boils down to is essentially, let's look at the person who's supposed to be carjacked and robbed to see what value his testimony is to you. Well, Homer Ellis testified that he was leaving that bar location, and he said that he saw two individuals, not three, but two individuals get out of a vehicle. But he was asked a number of times the $1 million question in any case, can you identify them in court? Page 42. When the prosecutor asked, now you say robbed, what do you mean robbed? He says, well, by gunpoint, they basically like robbed me for my car by gunpoint, but they had masks on, so I couldn't really say who did it. Question, so you didn't see the individuals that robbed you in the courtroom today? Answer, no. So it's clearly established to the prosecutor's own questioning when Homer Ellis stood on the witness stand and looked over here at my client. He didn't identify him as one of the robbers. Didn't even say he looked like him. Didn't even say his build looked like him. Didn't say anything. He said, no. Well, he's asked inquiries and goes on to say, regarding the license plate of his own vehicle. He said, do you recall, he was asked, do you recall the plate of your own vehicle that was allegedly carjacked? No. He's shown a report, but that didn't refresh his memory. He didn't know, did you give the license plate of the vehicle that was carjacked to the police? No, I didn't. Do you recall what time this event occurred? Answer, no. I just know it was late. And that's his initial answer. He can't even give you guidance as to what time this actually occurred. And then he takes a stab and he says late, like maybe 1 or 2 o'clock. So it could have been as early as 1 o'clock. We don't know. That's certainly not certainty that helps his court. He's asked, remember the serial number of the clock 9? No. Did you ever know the serial number of your clock? No. How many individuals arrived? It was 2 or 3. Then later he says it was only 2 who got out of the car. He made us saw 3 in this white Malibu. White Malibu. Remember that detail because it conflicts with what the officers testified to on surveillance, which I'll get to in a minute. And then he said that what he did, this is not a alleged carjacking where he's in the car and the car is taken from him. He says he dropped the keys to the ground. But he's not even near the car at the time he drops the keys on the ground, because he said over and over again that he was somewhere else. Again, he's asked on direct whether he's able to identify the people. He said no, they had masks on. Do you remember any other identifying features of these individuals? No. You didn't give the police any identification as far as the race of the individuals? Answer, I couldn't really see. Did you notice anything else about the individuals around you? No. Did you notice anything about the guns? I know that one of them had a beam, but I forgot the color. So he can't even give assistance as to the color of a beam. Now, when you're looking at a circumstantial argument case from a prosecutor, you want to see if details match up, because we have no direct evidence. And the details are all falling apart as far as I can see here. When you got the complainant who provides no assistance in terms of license plate, as to the vehicle, in terms of serial numbers for the gun, color of the beam of the gun that it was allegedly used in him. What type of vehicle were they in? He's asked on page 49. What's his initial answer? I don't know. So this is a complainant who doesn't even know what kind of individual, what vehicle they were in. So then a leading question was asked that I quickly objected to, where she's asking, do you recall telling the police they're in a white Malibu? And you sustained that objection because clearly it was a leading question because he didn't know what type of vehicle it was. But then it comes back and says it was a white vehicle with a black bumper. And it goes on to say it was a white vehicle. Did the Charger and the Malibu go in the same direction? No, they went in opposite directions. On cross is where it came out, where he says that he dropped the keys to the ground, but on page 61 he admits that his vehicle that was taken was around the corner. So not only do we not have an identification of Mr. Jordan as being one of those persons in that parking lot, we don't even have a carjacking because the vehicle is not taken from him when he's in the vehicle or in his immediate presence. It's around the corner, which defeats one of the elements of carjacking. Now, reference was made to Officer Mativa's testimony, which again, I don't think helps the prosecution in any way because he starts talking about a different color Malibu that he's watching on surveillance on page 15. What color was the vehicle? It was like a greenish, dark color. Can't recall exactly what color. Okay, so he's talking about a dark vehicle in terms of relation to this Malibu. But Homer Ellis, one thing he did remember, it was a white vehicle. So we have the wrong type of color vehicle that he's on surveillance. And then he changes it from greenish to grayish, but never gets around to ever saying that it was a white vehicle. So again, when you argue circumstantial evidence in this case, and the circumstantial evidence doesn't match up as to finite details, you're falling short of probable cause. Page 19, and based on your investigation, do you know who was the driver of the stolen vehicle? Because Ms. Scott just argued that it was my client. The answer is that was Mr. Jordan. I objected. I said there's no foundation to that. And guess what? This honorable court sustained it on line 22. So how's that anyway establishing that my client was the alleged driver of that vehicle when you sustained my objection to his wild speculation that my client was the driver of that vehicle? And of course, he gave further evidence how there were live lineups in the case that included my client. He was not selected in the live lineups as being one of the persons involved. So, and then there's arguments being made about somebody's medical records or even my client's. Judge, I don't see when you add up all the evidence in this case, how that in fact this case arises at all to the level of probable cause to believe that my client was in that parking lot late at night committing this offense. There clearly is no direct evidence. He's not identified in any way. There's wildly inconsistent testimony about the alleged vehicle that person came in terms of the color. There's just insufficient evidence when you add all this up to the level of probable cause. So I would ask that all the various counts filed against my client be dismissed. Thank you.
All right, thank you, Mr. Cruz. Mr. Reeves, whenever you're ready.
Thank you, Your Honor. Yeah, I join Brother Councilman's argument that there is nothing that says that my client did a robbery or did a carjacking. It seems, first of all, Mr. Ellis seemed to be a very, at least from my read, I did not have the benefit of seeing him testify, but it seemed like he was a very disinterested witness. Couldn't identify anyone. Height differential, color differential, someone pulled a gun, he didn't say that their hand was light. He knew nothing about these people. Couldn't tell you anything about the people that robbed him. Next thing that we have is we have the officers arresting Mr. Jordan and Mr. Strother at a BP gas station, where I guess Officer Mativa said he saw a gun on my client, and I took the gun from him. Yeah. At this point, there's nothing that said that they did a robbery. There's simply no proof that they did a robbery. Now, fortunately, my client sat down with the police, made a statement where he admitted to certain things. Yeah, and I asked, and you probably experienced, there are a number of different reasons why people make statements, why people admit to things that they may not have done. He may have been attempting to correct somebody. He may have felt that they will go easier on other people. This is a 17-year-old man who, at the time, was a 17-year-old man who maturity level may not have risen, or who logical functions may not have risen to something that an adult would, and just panicked and just made a statement. I did this. Somebody may have told him something. But what we have here is simply nothing that's said in the proofs that he did it. Officer King took a statement, and it seems like they cut off all investigation whatsoever as to try to prove that Mr. Strother did anything. Well, we got a statement, we're done with it, without any proof whatsoever. Now, I think this is simply lacking in anything that shows that my client was involved in this, but for the fact that they say they saw a gun on him. You know, Homer Ellison didn't testify. I don't recall anyone else testifying, but Homer Ellison certainly didn't testify that he could identify my client. And I don't think there's enough here for a body.
All right, thank you, sir. Ms. Scott.
Your Honor, may I retreat people with the fourth? Your Honor, I'll start with defendant product. Attorney Regan stated that there's no evidence of an armed robbery. The evidence for armed robbery are merely that a defendant uses force or violence or the threat of force in the course of committing a larceny, and that the complainant was present while the defendant was in the course of committing that larceny, and that while committing that larceny, defendant possessed a weapon or fashioned in a manner to lead the person who was present to really believe that it was a dangerous weapon. Mr. Harmon Ellis testified that there was a gun pointed to his face with a laser. That's enough for armed robbery. Defendant stated he gave a voluntary statement. I went through the voluntariness. He voluntarily gave a statement, not under duress. He stated that he took the charger, I picked up the keys and drove. He drove off in the charger, which is consistent with what Thomas Ellis stated. I'm not going to belabor the point. He said, the officer asked, did you have a gun? Yes. Did you show your gun? Barely. Well, it was enough for Mr. Homer Ellis to throw his keys on the ground. Mr. Cripps wants to go with the theory that, oh, the complainant couldn't make a positive identification in court. He didn't see anyone, so my client didn't do it. I've already given the court the case law. I've already given the court the jury instructions as to what is needed for circumstantial evidence. You have to look at the circumstances. You don't see the wind blow, but you know it exists. You can't describe it. If I was asked this court to describe the wind, you couldn't. You see the effects of wind. You see it when it blows. You know when it doesn't blow. You can look at a tree if the wind is blowing and see that it's moving. This is a classic case of, although you didn't see it happen, we know it's logic. We know that he was in this vehicle. This is circumstantial evidence that Mr. Jordan drove his father's vehicle, was with Strawber. At the time, they are they're aiding and abetting each other in pursuit of taking this man's vehicle and his gun. They're found with his gun. The records place them there. His cell phone places him there, the same cell phone that he's found with. We see the effect of someone who took the car. They're found in it. The effect of someone who took the gun. They have it with them. This man's gun and his vehicle. All I heard the defense say was, it's a question of fact for the trier of fact. I asked that you buy this case over.
That's not what it's.
No,
That's my theory of the case.
yeah, but we're making a record here. That's not gonna fly. I had a chance to hear the evidence, in this matter. And, you know, I start with this, you know, this is a preliminary examination of standard is probably whether there's enough evidence to proceed to circuit court or a trier of fact to hear the case and make a determination based on the evidence that there is enough evidence. And I do believe that the people have met their burden to both defendants as charged. We heard from numerous, well, let me start with Mr. Ellis. Mr. Ellis indicates that on the night in question in the area of 6 Mile, I want to get this straight. I know I think it was Greenfield, but it was a bar on 6 Mile. While he was walking his relative out of that bar, his approach indicates 2 individuals in masks. He makes no IDs of the individuals, and that is that much clear. I don't believe that Mr. Ellis was hiding anything. I think he was quite honest in his assessment. I didn't see anything. I don't know. I just know that these individuals pointed weapons at me. One pointed a weapon with a laser pointer at me. They asked for my items, which he complied. He threw his keys down. They took the weapon off of his hip. He indicated they immediately went to his car, his Dodge Charger, and they took off. The 2 individuals took off and the Malibu took off. He also indicated that he called the police, told them that it was a white car with a black bumper. That was the car in question. And the police did their investigation. And then within 2 hours, they had a ping to an apartment in the area of Telegraph and Riverview, where that stolen car was located. And on top of that, that Malibu that white car with the black bumper is also at that house. Three individuals get out of their car, three individuals get into the stolen car. And then they head to, I believe the next place that they stop is the gas station. And at the gas station, three individuals are arrested. Mr. Jordan and Mr. Stroder are found with weapons, at least described them from the officers, literally in their laps. I would note that the car was later to be determined to be registered by a person by the name of Terrence Jordan Jr., which I have, Terrence Jordan Sr., excuse me, which I have no indication of who that is, but my assumption is it's related to Terry Jordan Jr., Terrence Jordan Jr., but I don't know. We also have a phone taken from that location that is registered to a Janae Jordan, which is not Terrence Jordan, but I believe that there's an email associated with a Meta account, excuse me, that was with that phone, which could possibly be the defendant, but we know that the email relates to somebody by the name of Terrence Jordan. I don't know who that is. What I do know that there was three individuals that got out of the car on the river. Out of that same car, those three individuals got into the stolen Dodge Charger an hour within this incident and were arrested with weapons, including one weapon with a laser, which was also testified by Mr. Ellis, a gun that was possibly used in that location. Not to mention the fact that there was a weapon also recovered from that stolen Charger that was registered to Mr. Ellis. Now, this is not direct evidence. I want to be clear on that. Nobody can testify that I saw Terrence Jordan, I saw the Kyle Stroder, pull a gun and take those items from Mr. Ellis. There's enough evidence on this record to take this to a trial of fact. And I'm going to find the defendants over as charged. Mr. Jordan. One more thing as to Mr. Jordan and Mr. Stroder. Count one is charged carjacking. There was testimony from Mr. Ellis that coming out of that bar, and after he decided to walk his sister to her car, he was approached by the individuals who were robbing him. They asked for his keys, and they took that gun away. And the testimony was they went directly to that Charger. And I believe that there's enough evidence on this record that the intent of this robbery was in fact a motor vehicle. So I believe that there's enough evidence to proceed with the carjacking count. Count two, robbery as armed as to both defendants. Count three, weapons carrying concealed weapons as to both defendants. Count four, I'm not going to bind over instruction as to Mr. Stroder, excuse me. Count five, the felony firearm as to both defendants, I am going to bind over. Arraignment dates September 14th, 2023, Third Circuit Court. I do not know what this case is going.
Client pending cases from Judge Richard Haskell.
So I'll probably go to Judge Haskell. But you guys deal with other courts outside of me, so we'll leave it at that.
And Your Honor, before we go off the record, there's two issues I'd like to bring up. One, Your Honor, I know I've asked several times, but I make a renewed motion for reconsideration of bond. Your Honor, again, as previously said, my client does not have any new cases. The case that caused the situation that caused my client to be incarcerated, to my knowledge, he had not been charged in that case or any other case. His bond
Still hasn't been charged.
that's correct. And Your Honor, he did have a substantial bond. I believe his bond was $100,000 surety bond. 10%. It was a substantial bond, but his bond was fair. He made that bond, Your Honor, and he did his best to abide by the rules of the court with the bond. It's unfortunate that a situation happened where he was present, but then merely being present does not mean that my client is suddenly in danger because of that. So, Your Honor, again, I respectfully ask that his bond be reinstated.
All right, Mr. Riggins and Mr. Strotter, as you all know, we've had quite a history with this case. I know a condition of this bond, no contact with weapons. While Mr. Strotter was not charged, he was in the car. His co-defendant on this matter, who was also out on bond, 2 weapons found in that motor vehicle. I can't stress, and not only have I stressed this on so many occasions, the fact that I'm in this situation again, and the fact that this has happened after Mr. Strotter was given this bond after what happened in Oakland County on top of it, I just find, it's insulting to all of us. I believe that he creates a danger to the community by his presence right now while this is, before this is resolved. And, I believe that the remand is a correct ruling this time. It's going to stay there. But, I lose jurisdiction after today.
All the court hearings we had, there was a keep separate order, where my client and Mr. Jordan could not be brought to court at the same time. I spoke with my client regarding this because frankly, I wondered what this was for. He has no idea. There has been no interaction between the two where there is a need for a separate order, Your Honor. So to the extent that maybe the court might have ordered a keep separate order,
I ordered it. They're co-defendants on the case. I have the ability to order that they kept separate, and I ordered it, and it was granted.
Right about the jail?
Yes.
So,
We
Judge,
don't really call that an order.
that judge, I like, well, I'll wait till my turn to press that.
Okay.
That's an ex-parte thing, it shouldn't have been done, we should have advised it, that so we could argue.
Well, first of all, this is not an order. This is a request by the jail. I decided it ain't nothing to come to me as to that. I didn't order anything. The prosecutor didn't approach me about that. So, I think, we're calling this an order, but it's not,
Well, my point was I requested it, Your Honor. It was in my authority to request. I requested it. It was granted. It's common practice for defendants to be kept separate when they are co-defendants on a case.
At this point, the judge Hathaway should, if they're gonna change that order, let's leave the judge Hathaway. Because I didn't order that, and if I would have a hearing on it, or at least, hear both sides. This didn't happen, this was directly went to the jail, and, they decided to do what they're gonna do, but no.
I request a bond to be
I'm
set.
sorry, what do you guys?
my apologies, Your Honor.
It's just sad, sorry, just feel bad about this whole situation. But I'm sorry, Mr. Ritchie.
Yes, I don't know what happened, Judge, I've been facing you, but on behalf of Mr. Terrence Jordan Jr., he's been under remand status. I respect your decision in terms of the bind over. But obviously now, down the road, it's gonna be a much higher standard of proof. And so you can weigh that in terms of at least setting a bond here. So I'm asking that the court lift the remand and set a reasonable bond on behalf of Mr. Jordan.
At this time, I believe that there's enough information to proceed. Probably, it's not gonna make a determination as to the likelihood of conviction, but I won't do that at this point. I believe, it's not fair. I don't know if that was presented to the court, but they presented their trial analysis. Probable cause. That being said, you know, violated my order as far as, the bond that was originally set. As a consequence of violating that bond, I don't believe that, I don't believe the community can be safe with this person out while this matter is remaining continuous.
Thank you, Adam.
Thank you, Your Honor.
That concludes this hearing.
Thank you, Judge.